Good day, sir. Today we'll be presenting on damages for breach of contract. Before I start, let me introduce myself. My name is Tarani Vijay with the metric number of MC250132909. Now let's begin. Damages for breach of contract are monetary awards meant to compensate the non-breaching party for financial losses suffered due to the contract failure to be performed as agreed. There are several types of damages. Firstly, compensatory damages. These are intended to put the aggrieved party in the position they would have been in had the contract have been properly performed. Secondly, nominal damages. These are awarded when a breach has occurred but the aggrieved party has not suffered any actual loss. Thirdly, liquidated damages. These are predetermined amounts agreed upon by the parties at the time of contract formation to be paid in the event of a breach. Last but not least, exemplary and punitive damages. These are rare in contract law and intended to punish the breaching party for particularly egregious conduct.
Hi, my name is Katija and I will elaborate based on the legal principle. As start based on the slide, this section indicates an innocent party may file to the court to entitle the compensation for the loss for the breach of contract, which such reasonable as foreseeable losses. The claimable shall be compensated based on the court order, whereas the charge is reasonable amount not exceeding the actual nor directly charged to the full sum. This extends that in order innocent party to be compensated reasonably, the duty to mitigate the loss has to perform in proving the act to reduce the amount for the loss that fails to do so may lead to the reduce the amount of compensations. Example applied to the case law Hadley versus Bezendil 1854, Selva Kumar anak lelaki Murugia versus Tiaga Raja anak lelaki Retnasami 1995 on the entitle of compensation, while Ketabasan Timber Extraction Company versus the Government of Sarawak 1926 for the duty to mitigate the loss. The measures may be classified: first, the substantial, whereas an innocent party has to suffer actual or total loss due to the breach of contract that demand to be compensated to equivalent to the actual loss. Case law Hadley vs. Balsendale 1854. Second, the nominal, although the breach of contract is proven but the actual loss is just mere or no actual has been suffered. This awarded in a knowledge their legal right which violated. Case law Fuchs vs. Beer 1884. Last, in exemplary or known as punitive damages, not meant to compensate, rather to be punished, and its special case, whereas the defendant proven fraudulent breach or conspicuous act breaches the contract, like the case law Roots vs. Barner 1960.
Everyone, I'm Ganga Maripan. My matching number is MC250534333. And now I'm going to explain about the case law that is related to our topic, which is damages for breach of contract. The case I chose is one of the most famous cases in contract law, which is Hadley vs. Baxendale in 1854. In this case, a mill's crankshaft had broken and the mill's owner hired Baxendale, a carrier, to deliver it for repair. But Baxendale delayed the delivery, and because of that, the mill could not operate for several extra days and causing the owner to lose profit. The owner sued for those lost profit in court, but the court decided that Baxendale was not responsible for them. Why? Because he didn't know that the mill would have to stop working until the part was returned. The key principle here is that damages can only cover losses that are reasonably foreseeable by both parties when the contract was made. In a short, if a loss is unexpected or not communicated, it is too remote to claim. That's all from me, and my teammate will explain how this case is related to our topic. Thank you.
Hi, I'm Maisara and I will be explaining about how this case relates to our topic. So the first one is foreseeability of loss. So when a contract is made, both parties expect certain things to happen. Damages can only be claimed for losses that both parties reasonably expected could occur if the contract was broken. If a loss is surprising or unusual, no compensation is given. The second one is limitation on damages. The breaching party is only responsible for losses that naturally come from the breach or were known by both parties when the contract was formed. They do not have to pay for unusual or distant losses that were not anticipated. And the last one is duty to mitigate loss. The injured party must take steps to reduce or avoid losses after the breach happens. They cannot let losses grow bigger and then demand full compensation for all of those losses. This duty helps keep things fair. Thank you.
Hi, my name is Swendra Shanmugam. My metric number is MC241031592. In conclusion, damages for breach of contract are meant to compensate the innocent party for any loss caused by the breach. The purpose is to place them in the same position as if the contract had been properly carried out. According to Section 74 and 75 of the Contract Act 1950, compensation must be reasonable and only for losses that are foreseeable. The case of Hadley v. Baxendale supports this principle. Only predictable losses can be claimed. There are different types of damages such as substantial, nominal, and exemplary, depending on the situation. The innocent party must also try to reduce their losses after the breach. Overall, the law ensures fairness, responsibility, and justice between both parties. Thank you.